Okay, so and we are I am recording this for prosperity. So welcome everyone to Mass General Law chapters 1, 2, 3. There's been a tremendous amount of interest in this, so we're really excited to present this. This is the first of 3. It will be repeated, so it is not a series, just for people to know. And I am Julianne Flynn. I am with the Office of Inpatient Management, and I'm clinical training specialist. You may have, I may have worked with you at a facility or two in the past. I try and stay connected to the facilities as much as possible. And so today we are going to go through chapter 123 and know that this is the February. We're also going to have it in June, the second Thursday of each month of February, June, and October. So if folks know that there are people who could not make it to this session, it's going to be offered again. And so we will repeat these. So we are going to ask that people turn their video off unless they're speaking or a presenter, only because we do have over 100 people expected on this call, and that will help with bandwidth as well. So if you could do that. And also when you joined, your microphone was off. So if people could remain muted until we do the question and answer period, that would be great. And then what we're going to do is we will present a slideshow. Our presenters are going to, discuss material, and then we will have a Q&A session. There's also, I just want to alert you to the chat feature. So depending on how you are set up on your Zoom, it will either be on the top of your screen or the bottom. And at any time, if you have a question that is something, really pertinent that you have to have the answer to kind of right now, if you can put that into the chat question, we will interrupt and we'll make sure that we address those. Otherwise, if people could hold until the end, that would be great. But we do want this to be as interactive kind of as we can and dynamic. And as we were talking, as some of you may not have joined us yet, the discussion sometimes goes off where it needs to go. We want to make sure that we allow some time for that. So we've allowed at least a half an hour or so for some really, really deep dives into some questions and nuances of the laws. The other thing is most of you have asked to register in order to get, if you wanted CE credit or certificate of attendance. I will get attendance right from the Zoom link or in emails. That's why I asked for people to register with me. So if you're on the call and you did not register with me, Julianne Flynn, please shoot me an email. This will ensure that you receive the evaluation. In order to get CE credits, you will also have to complete an evaluation. Once that's completed, you will get a certificate as well for that. Any questions you can get to me after. So I am going to turn this over to Dr. Saleh to introduce the learning objectives and then introduce the panel presenters.
Thank you, Julianne. Good afternoon and welcome everyone. Happy Thursday. My name is Imam Saleh. I'm the medical director for the Office of Inpatient Management. And I am not sure if our Dr. Kathy Sanders has joined. If she is on the call, I would request her to make, if she wants to make an opening statement, that would be very nice. I don't think Dr. Sanders is here yet. And I actually practiced this, so I should be able to do this. So, well, it gives me enormous pleasure to launch a series of training that is going to, that we're going to launch in 2023 under the leadership of Dr. Mary Louise White, who's the Director of Office of Inpatient Management, who unfortunately is not here today. She's on vacation. I want to express my gratitude to the panelists who are multidisciplinary. They come from 3 different disciplines: psychiatry, psychology, and legal. And a lot of them are our friends, colleagues, subject matter experts, and truly dedicated public servants. At least one of them has been my supervisor and a mentor for over a decade, Dr. Paul Naroyan. but I am going to introduce, before I do the introduction, the overall goal of this training is to inform participants, inform and educate. A lot of us already know about these things, about the mental health laws with a specific focus on Chapter 123 in the Commonwealth of Massachusetts. And the objectives would be, and we're going to modify this training and make changes based upon participants and panelists' feedback in future. But for today's training, the learning objectives are compare and contrast various legal sections as they pertain to DMH patients and clients that we serve. And the second learning objective is to articulate the differences and key legal concepts and components of most frequently encountered legal statuses in the DMH facilities. And finally, define key differences and treatment implications for patients who are admitted to us under a voluntary versus involuntary status. Next slide, please. So the major presenters today are, Dr. Ashley Marie and Dr. Daniel Renzak. I want to say a few words about the two of them. Dr. Marie is an assistant professor of psychiatry at UMass Chan Medical School. She's a designated forensic psychologist, also a forensic mental health supervisor. She's done many trainings for the Department of Mental Health, for various trial courts, for UMass Chan Medical School. She is also the Director of Forensic Psychology Fellowship at UMass Chan Medical School. Dr. Daniel Renzak also is an Assistant Professor of Psychiatry at UMass Chan Medical School. She also holds teaching positions in the medical and law schools at Northwestern University. She's also the incoming training director for legal education, I think beginning this summer. Next slide, please. And the other panelists are Dr. Margarita Dow. She is the Associate Director of UMass Chan Forensic Psychiatry Fellowship. She's a forensic psychiatrist by training, also an attending psychiatrist at Worcester Recovery Center and Hospital. David Coleman has been an attorney for the Department of Mental Health for about 16 years or so. And he is based primarily at Shattuck and Fuller and covers the Metro Boston area for the Department of Mental Health. Dr. Adeliza Olivero is a court clinician based at Roxbury Court Clinic. She's also a designated forensic psychiatrist, works for the Forensic Division for the Department of Mental Health. Nate Frommer is an Assistant General Counsel for the Department of Mental Health out of Worcester Recovery Center and Hospital. We're very truly lucky to have John D, and I'm going to do my best, John. John D. Pietro Antonio, who's the Deputy General Counsel for the Department of Mental Health. We're truly lucky that he's found some time to join us. Paul Naroyan is the Director of Forensic Psychiatry Fellowship at UMass Chan Medical School, an Assistant Professor of Psychiatry, and also the Director of Psychiatry at Worcester Recovery Center and Hospital. And Dr. Dinsmore, who's not here with us today, and we don't have her picture here, she's also a designated forensic psychologist and an Assistant Professor of Psychiatry at UMass Chan Medical School. We're going to have a presentation of roughly about 45 minutes, followed by an open Q&A session. I would invite folks to, either speak their questions clearly and so that we can record it properly, or write down their questions in the chat room, and I'm going to monitor it. I am going to stop here and invite Drs. Marie and Renzak to begin the presentation. And thank you so much.
Hi, everyone. I'm Dr. Danielle Renzak, and I'm going to get us started. Our thoughts were that the best way to kind of go through Chapter 123 would be going through the process of a forensic evaluation and how those cases are referred to us. And while I may be speaking, there's a whole panel of experts that are here and can jump in if they're for further elaboration. So Dr. Murray is doing the slide. So excellent. Thank you, Ashley. So the first thing that we'd like to get started with is the process of the referral. So in court, when a defendant comes into court, an attorney may raise a question about competency or sanity at that time. They may have, for example, the attorney may have concerns about how their client is interacting with them, or perhaps misunderstanding some of the information or having trouble communicating, or may have a history of mental illness that may impact their competency, or the situation in terms of the alleged crime may indicate some concerns about sanity or criminal responsibility. So the attorney may raise those issues and request that an evaluation be conducted. Even if an attorney does not raise those questions or concerns, a judge sua sponte, or the judge by him or herself, may raise those issues as well. So they may request that screening evaluation. Essentially, those concerns are communicated either to the judge if it's through one of the attorneys, or the judge, he himself or she herself will order that screening evaluation pursuant to MGL Chapter 123, Section 15A. And that is, again, a screening evaluation that's conducted by the court clinician, who completes that evaluation the same day, either in person or virtually. With COVID-19, they've had to do much more things virtually. So they will either go to the cell where they're being held and do that evaluation, or they may have to do that evaluation virtually. And then that evaluator will make written conclusions about competency or criminal responsibility, or both, depending on that referral for the screening evaluation, and make a recommendation of whether or not that person they believe should require further hospitalization or further evaluation, more thorough evaluation in an inpatient setting. If they don't believe that the person needs to have that evaluation in an inpatient setting, the court clinician may recommend that they do it on an outpatient basis, but we'll be seeing in our respective hospitals that request when it's for an inpatient setting. That court clinician is doing it all that day. In addition to meeting with the person or the evaluee and making recommendations, they're writing that report quickly, and then they have to go to court and testify to that opinion. And then the court determines if that evaluee should be sent to an inpatient hospitalization pursuant to MGL Chapter 123, either Section 15B or Section A. And the difference between that is the Section 15B is the most common evaluation we're getting for competency or for criminal responsibility. A 16A would be if they've determined that that person is already incompetent or not guilty by reason of insanity. And then they're just requesting that we look at that patient and evaluate them in terms of whether or not they meet commitment criteria. So typically we're seeing the 15B where we're doing a thorough evaluation of both competency and or criminal responsibility, or possibly just criminal responsibility there. So this is typically based on the evaluator's opinion, but can be done by the judge despite that opinion. So even if the court clinician is opining that they don't need that inpatient setting for the evaluation, the judge can individually go ahead and send them to a hospital for the evaluation. And then the patient, which is always complicated to me because it's behind the scenes, but the patient is going to be assigned to one of the hospitals that has bed availability. And that's determined in part with the help of the area forensic director for that court's region. All right. So admission details. So when they're ordered to have that inpatient evaluation, oops, let me move that. What we get on our end as the forensic evaluator is we're going to get an order that includes the next court date, and the time in which we have to complete that evaluation. So it's typically 20 days if it's a 15B. And the evaluator is actually going to be turning in that evaluation the day before court. So if the date, so that's typically 20 days, and then they're going to be seen in court. So the forensic evaluator is not actually going to be doing that evaluation, submitting it the day of court. We have to complete it and send it in typically by noon the day before that court date, so that it can be distributed on time and so forth. So sometimes there's some confusion about that. The next court date is we're actually turning in that report the day before that next court date. So we have a little bit less time in that sense. The documents are sent to the hospital, and that typically includes the 15A screening evaluation, which is very informative, the police records or reports that have information specifically on those allegations that we're looking at for competency or for criminal responsibility, and then prior evaluations or available records that the court clinician may have. So sometimes an extension is requested if additional time is needed for the evaluation. And the 15Bs allow an evaluator to request additional time, but no longer than 40 days after the original 15. So typically we're getting 20 days initially, and we can extend up to 40 days. So typically we have up to another 20 days. All right, so that forensic evaluation, it's usually the forensic evaluator that's going to reach out to the team and make that initial contact that says, hi, I'm Dr. Rinchak. I'm going to be the forensic evaluator in this case. This is how you can contact me. And I'm looking forward to working together and to have input from the team on a variety of aspects. And that team includes the psychiatrist, but also the psychologist, the social worker who's going to be working on discharge planning, as well as the head nurse, who is often in the best position to say how that person is interacting and presenting on the unit. So we want everyone's input. We want to be collaborating as a team. The forensic evaluator is going to be looking at relevant documentation. So this includes, again, the 15A screening evaluation, the police records that accompany that, any prior records that the court has that they want to give to us. And very importantly, we're going to be looking at the electronic medical record. So we're going to be tapping into what the team is reporting in the record. This is extremely important because we want to see the different team members' perspectives on things. We are going to be, the forensic evaluator is going to be doing collateral trying to get collateral sources of information, and that oftentimes we don't need, like the team often needs releases of information, but forensic evaluators don't to do collateral interviews and to contact like family members and things like that. So sometimes we're privy to additional information that the team doesn't get because the patient doesn't want to sign releases. And we can share some of that information as it pertains to risk, so that we all have similar data. We're going to conduct interviews, administer testing. That testing, we often do not use testing in competency evaluations, for example, but we will sometimes use that to check in for diagnostic clarification. When the picture is not clear, we may administer some of our own testing. We may do some feigning testing to see if there's possible feigning. If there is, they're different. They're presenting differently across who they're meeting with. And if it's neuropsych testing, we typically refer that out to the neuropsychologist, and that often requires us to extend a little bit and ask for additional time so that testing can take place and can be included in our evaluations. We are collaborating with the treatment team regarding level of risk and recommendations to the court, which include whether or not the hospital intends to petition the court for commitment. So just to go back and elaborate a little bit on that, our collateral sources of information, the forensic evaluator can reach out and do interviews and so forth, where we're collecting data, but not releasing data. However, if we're looking for additional hospital records, we will need oftentimes that release of information. So we may not be able to get that, or we're asking the team to share that information with us. The report is going to be written addressing the legal question, the risk, and the recommendations for need for further care and treatment in the hospital, including discharge planning. And oftentimes we're going to be looking and dependent on the treatment team if the patient is declining to meet with the forensic evaluator, but is meeting with all of you. We're definitely going to talk to you, email you, try to get as much information from all of you if we're not able to get that firsthand. Okay, let me just check. Okay, so the UMass DFP service contracts with DMH to perform the service. So we don't often need to duplicate releases of information. We're able to use the same ones that you're using. Sometimes they feel more comfortable giving us information and not the hospital. So we'll get a release that says that I can get some information, but doesn't include the treatment team. So we kind of work around that in some ways so that we can still communicate to the team what we're able to communicate, especially as it pertains to risk and discharge, opinions about discharge.
Sorry, just
Yeah.
to jump in. I think this also
Yes,
relates
please do.
to the fact that I've had teams in the past, they're not sure if they can share, if they get the patient to sign a release for like outside hospital records, they don't know if they can share those records with the DFP. And I think that's also the point of this bullet point, is that yes, hooray, you can share it with us. So we don't need to get two separate release forms signed by the patient. The one release for the records from Pembroke Hospital, for example, once you get those records in your admin, you can then forward those to the DFP. So we're all on the same page.
Yeah, exactly. Thank you, Ashley, or Dr. Murray, for that. That's exactly right. We don't have to, we don't want to duplicate those things. The treatment team team does need a release of information to communicate with outside providers or obtain records, but again, the DFP does not. So we can oftentimes reach out to folks that you're unable to, but then again, we'll be able to share that risk data. The team also cannot communicate with individuals relating to like a restraining order against the patient, though a DFP can. We don't always try to involve the alleged victim, and sometimes that information is redacted in the police records, but we can reach out to the ADA or the prosecutor and get that information. And sometimes we'll go through them to just be clear with the alleged victim or the person that has the restraining order that they do not have to talk to us, and that they can consult with like a victim advocate through the DA's office or their own counsel before speaking to us. But we can definitely reach out and try to get that information. I saw that there were a lot of questions and things in the chat, which we'll get to later. And I am going to talk about legal risk issues for testifying next. So there's definitely risk that exists outside of evidentiary requirements, but we can only get that risk data in front of the judge in court if it's allowed in. And so there's these complicated hearsay things that I think the attorneys are best equipped to answer if there's some nuanced questions. But if the risk is based solely on out-of-hospital incidents, then we make efforts to inform, well, you want to make efforts to inform your hospital counsel ASAP so they can try to contact these people as witnesses. So if the risk is there, you can always testify as to your opinion. But if we need, if they're doing okay in the hospital, we may need other folks to testify. So sometimes we need police officers who have interacted and they can talk about, you know, that any information that goes to risk, like how they were behaving at the scene, if they witnessed it firsthand, if they thought that the person needed a 12, for example, they can talk about that presentation that they had. So we want to reach out to police officers. Also, anybody that petitioned for a restraining order may be able to speak to the fear they have for their own safety, even if that person has not physically done any harm to that person. We want those people to be able to testify because those things we're not going to be able to testify because it will be hearsay. So if you have other people, family members that feel they're at risk or can speak to any of the risk, we want to get in contact with them right away. So we as forensic evaluators will contact hospital counsel, but you as a treatment team also want to do that so that we have a head start in trying to get folks involved if they're so inclined to testify and strengthen the case.
I would, sorry, I would say
Yes.
most often, this would be like 99% of the time, it's going to be family members who can talk about the risk issues that were happening, like Dr. Rinchuk said, in the community. And a lot of times too, it's outpatient DMH providers, like case managers, things like that would come in and talk about, well, you know, geez, right before they came into the hospital, they weren't taking their meds. They were doing this, that, or the other that was risky in the community. Again, like she said, things that we can't, as the DFP, talk about because it's just hearsay to us. So if social work, for example, you're talking to the DMH outpatient folks and they relay concerns, there's a good witness. We as the DFPs get to talk to family, like she said, and a lot of times treatment teams can't unless an ROI is signed. So then we're approaching legal to be like, hey, reach out to this mom or this dad, they're willing to testify.
Yes, exactly. Thank you, Dr. Murray. So as far as the legal analysis of risk, which I think the attorneys can speak to more, that there's no need for recent overt event of dangerous behavior. How soon the risk is predicted to materialize varies in proximity with the severity of the harm to be prevented. So I would say there that sometimes we hear from folks on the team, well, the person hasn't done anything in the hospital, so we shouldn't keep them. But if there's lots of risk, and the target of their delusions and who they're, making threats about or to are on the outside, then again, we don't need them to express that dangerousness with being in restraints or something. If they still believe those delusions that so-and-so in the community is trying to hurt, is, that they need to go after this person in the community because that's, of their distorted beliefs, then that's enough. Like if they're still believing that. And so again, just because there's no dangerous act in the hospital doesn't mean that they don't have enough risk to be held or to be committed. So we're looking beyond that. We're looking at, other things in the community. That's why we're looking at collaterals. And that's why we're looking for other folks to be able to testify to some of those things, because we may not see it in the hospital.
Danielle, can I just jump in for a second?
Yes, please do.
Okay, just it's very important for the treatment teams to be giving the LAM warning. Again, they may be able to discuss events that happen in the community. And if they do it under LAM warning with the patient and the patient is open to talking to it, then they can get it into a hearing.
Yes.
So that can be very important.
Yeah. Thank you so much for that. Yeah, it's very important to do that LAM warnings. But there are also members of the team who don't even need the LAM warning. So sometimes we can get in through some of those folks, like individuals that are doing like OT or some of the nursing staff or things like that. But if you are a psychiatrist, a psychologist, a social worker, make sure you're doing that LAM warning and make sure you document that in the medical record that you've done, that you've presented the LAM warning, and that you checked in to make sure that the patient understood the LAM warning. For hearsay, why sometimes we can't communicate things that we didn't hear directly from the patient is because of hearsay. And the whole point of hearsay is that the person cross-examining must be able to cross-examine that information. So we want to get, the judge wants to hear it from the source of that information in its truest form. So that, again, also, they're not hearing it also from the truest form, but that the opposing counsel has an opportunity to cross-examine that information, which they can't do if I'm reporting something that someone else said, other than the party opponent, who is the defendant or the patient in this case. And your opinion in and of itself can be used to support a commitment petition. So sometimes you can say stuff like, I'm basing this on the information I heard from the police officer, the victim or the alleged victim, the family members, all of those other things that lend credibility to you, even if you can't say exactly what they said to you. It sort of bolsters your argument. Okay, so I think I'm going to pass the baton over to Dr. Murray, who's going to talk a little bit more about the processes that occur here.
Okay, so moving through our example of, let's say, somebody has the 15A screening evaluation done at court. Now they're at our hospital. The DFP is coming in and we're doing the evaluation. You're doing your evaluation as the team about, what are our thoughts about if they need commitment or not. Let's say that we all sort of decide this person does not meet commitment criteria. So pretty simple. Hopefully we need to all be on the same page. So we're constantly communicating with one another about our thoughts and opinions, sharing our risk data as we get it. And if we think they don't need commitment, then they are either discharged. Well, so no matter what, they're discharged back to the court for their next hearing, where they'll get the DFP's report which outlines our opinion and what the discharge plans are. In addition, you should be submitting, or social work should be submitting the discharge summary and plans on it. So they'll either be released to the community with those plans in place, or let's say they're held without bail, it might be the case that they are returned to jail. And then your job is done. If, let's say, we're cooking along on the 15B and we think, man, we need more time for treatment primarily, or maybe we want to do some more testing, or we want to get some more records in. One vehicle to keep the patient longer is that 15B extension that Dr. Renchek talked about earlier. So we could just, in the middle of the evaluation period, submit an extension request to the court for 20 more days. Another vehicle for extension is what's called a 16A, and that is at the end of the 15B period. In our 15B report, the DFP is writing, we still have some ongoing concerns and we'd like to keep the patient for longer care and treatment pursuant to 16A. A 16A allows us to keep the patient for 30 more days. So that means we would have them for potentially a total of 50. Although just like the 15B extension, we don't have to ask for the full boat, right? We could ask for one more week to really make sure that respite bed's in place. Or if we feel like we really need the 30 full days, we would be asking for that. In order, though, to request those 30 extra days for the 16A, the patient has to be opined incompetent. So the DFP is writing in their 15B report, the patient is, in my opinion, not competent, and we think they need further time at the hospital. So we're requesting that the judge have them stay on a 16A status. Pretty much always the judge agrees with this and the patient remains. I will say this is typically advised, like if, asterisk, underline, bold, if they're actually engaging in treatment. It would not make a lot of sense if we've got somebody on the unit who is incompetent, floridly ill, potentially getting aggressive, agitated, and we just keep them for 30 more days and they're just going to sit there not engaging in treatment for 30 more days. So if that's the case and we're really concerned about risk, we would just go straight for a 16B commitment, because only, as you're probably aware, only under that 16B commitment can we then have treatment staff request for like involuntary medication procedures. All right. So relatedly, let's say that we feel the patient does meet commitment criteria. And so we're all, again, communicating on the same page. We think we should commit this person. If they are incompetent to stand trial and meet commitment criteria, the psychiatrist is submitting a petition pursuant to Chapter 123, Section 16B. At Worcester Recovery Center and Hospital, the forensic evaluators, the DFPs, we do this, but at other hospitals, like Tewksbury, for example, y'all are the ones submitting that 16B petition. So the DFP submits their report to the court. This person is incompetent to stand trial, for example, and we think they need to be committed to the hospital. And then the psychiatry is putting that 16B petition with our report to the court. They get everything. And then what happens next is a commitment hearing is scheduled outside of the criminal court. So the patient is given a totally separate attorney, which is a CPCS attorney, to help represent them in the commitment hearing. At some hospitals, the DFP will be the one testifying at that commitment hearing about why we think the person meets commitment criteria. At other hospitals, like Tewksbury, for example, the psychiatrists are typically the ones who are testifying at that hearing. Okay. But let's say it's a case of the person is just sent to the hospital for criminal responsibility, or at the end, let's say they're there for a competency assessment, but at the end of the evaluation, the DFP thinks, well, actually, this person is competent to stand trial. They understand the court process. None of their psychiatric symptoms are getting in the way of their rational understanding of their court case. So that's all great. However, they're really posing a risk, obviously, to themselves, others, or they're just very unable to care for themselves. So we think even though they're competent, they need to be committed to the hospital. In that case, a different process kicks into place. And it's kind of like a confusing decision tree. So like buckle in and try to stay with me. If the person, let's say they have a bail status, and so, it's either they stay here or they go to jail, but we don't think they could handle jail or they're not going to get appropriate treatment in jail, we would ask the court to do what's called a Section 18A evaluation. So in kind of a laborious manner, the poor patient has to go out to court at their next court date, get evaluated by the court clinician, who then sort of, hopefully is liaising with the DFP from the inpatient side. And, we're explaining why we think they need to come back on an 18A instead of going to jail. And then they hopefully agree with us and they testify to that to the judge. And then the judge says, okay, I'm going to send this person back to the hospital for an 18A evaluation, which is a 30-day evaluation period. So the DFP now has 30 days and the team, DFP and the team now have 30 more days to decide if the person meets commitment criteria. And at the end of that 30-day evaluation, they'll submit documents to the court indicating this person needs to be committed to the hospital. And here is the 18A petition to commit. Similar with the 16B, there would be a separate hearing outside of the criminal court where that patient would have a CPCS attorney representing them, and an argument about whether or not they meet commitment criteria would thus ensue. If the person does not have a bail status, or they're on personal recognizance, or they could potentially pay their bail, but let's say they're competent, then it's turfed to the treatment team, and now you are responsible for trying to commit them civilly via Sections 7 and 8. So you, treating psychiatrist extraordinaire, would be submitting a Section 12 petition with our report to the court, where in our report we say the person meets commitment criteria, and so we are attempting to pursue commitment civilly. Here's this beautiful Section 12 petition. The judge agrees with that and sends the person back to our hospital, and then you need to file a Section 7 and 8 for commitment within 72 hours of the patient's return to the hospital. Hopefully that all makes sense. Okay, so if the patient, we have that commitment hearing, and then the patient, let's say, is committed to the hospital, and so they're here, they're under, let's say they were incompetent, they're committed as needing care and treatment and incompetent, so that's called a 16B commitment. So that first initial 16B commitment ordered by a judge has a shelf life of 6 months. So towards the end of that 6 months, there's going to, obviously you're evaluating as the treatment team if they continue to meet commitment criteria or not. As you approach, especially the end of the 6 months, obviously the court wants to sort of know what's up. So what I mean by that is they also want to know about the patient's competency status. So at any point during that 6 months, if you think the person has made excellent gains and are ready potentially to move towards discharge, at that point, you should be requesting a competency update evaluation. Or if it's getting close to the end of that 6 months, there's an automatic process that also kicks in to automatically order that competency update evaluation, but you as the treatment team have that power as well. So at any point you think, hey, maybe this person is restored to competency, go ahead and start that process to see if perhaps they have regained competency. Let's say at the end of the 6 months, the person still is not better and still meets commitment criteria, then you would be testifying again for additional periods of year-long commitments. So that becomes then a 16C commitment for the next year, on and on until the person no longer requires commitment and can be discharged from the hospital. All right. And this, is particularly kind of a balancing act as well, because once you initiate a competence to stand trial update evaluation, things get put into place, especially if the person is now competent. So, if the DFP comes in and does that competency update and says, like, hooray, the person is now competent, they need to move to let the court know that, and there needs to be a hearing within a relatively quick amount of time, a couple weeks, several weeks. They'll be drafting their new report saying the patient is now competent, and then they send that to court. And then a new hearing is set up. And so if it's the case that you're hoping to discharge before the expiration of the commitment, your timeline is potentially, in a sense, moved up a bit, because now they're going to be determined competent at court, which nullifies the 16B commitment. I made this sort of decision tree, which I've talked to some treatment teams about, because it can be a bit confusing, I think, about when to ask for the competency update, and then sort of what happens based on the results of the competency update evaluation. And again, this is for patients who are committed to the hospital, right? So let's say that you have this competency update evaluation, the DFP comes in, and the patient is now competent. Hooray. Like I said, we as the evaluator then need to write a report and submit it to the court in the next several weeks, indicating that the patient is now competent. And we are also now looking to you as the treatment team about what do you want to do regarding, are they ready for discharge, or are you going to try to recommit them? And based on that decision, you can see this splits. So if you are also planning to discharge the patient, then you're putting those discharge plans in place. And then when they go back to court, ideal situation, when they go back to court with this new competency update that says they are competent, you've got your discharge plans in place, and they can hit the ground running out of court. Obviously, we know how the system works and how difficult it can be to find discharge plans. So sometimes this is not always the way it goes. Sometimes, and a lot of times I've noticed, if you can, work with the patient to agree to have them perhaps sign in voluntarily on like a 10 and 11, it might be the case that they go to court, get found competent, and then they come back to the hospital as a voluntary status until your beautiful, wonderful discharge plans are ready to go. And then they hit the ground running. That, of course, is sort of contingent on them agreeing to do that. Alternatively, if you don't think either A, they're ready for commitment, they need to be in the hospital longer, or you don't think they can discharge with the plans available at this moment, and they need time in the least restrictive environment, that might be the hospital at this time, because you don't have discharge plans that would appropriately manage risk. You would need to then try to recommit the patient civilly via sections 7 and 8. So there would be a new commitment hearing, as like I said, once they're competent, that 16B commitment status that's been having them stay at your hospital is now null and void. So you're going to need to then pursue commitment civilly, like I said, via 7 and 8. Or let's say the patient is incompetent. So the DFP comes in, we do our competency evaluation, patient is still incompetent. If also you think they still meet commitment criteria, so they're incompetent and they need to stay in the hospital for longer, you would just be pursuing a new recommitment under 16B. So they're still incompetent, they still need to be in the hospital under this same status, 16B. And the forensic evaluator in that case would just need to write a note that goes into the medical record at your facility that says, I met with this patient to reevaluate their competency. They're still incompetent. There's still these risk concerns, and the team is pursuing recommitment. Or let's say the patient is incompetent. However, the treatment team feels that they've made their gains. They no longer meet risk criteria, and so they don't need to stay in the hospital. So in that case, they need to go back out to court, and the evaluator needs to write a report for the court saying the team is preparing to discharge the person, however, they remain incompetent. You also need to, I think that's a typo. You need to submit a 16E, I think is what it's called, petition 30 days before their discharge, before their commitment expires. And you want to make sure you're giving yourself enough time before the expiration date of their commitment to file that if you're planning to discharge the person. Relatedly, it's important that you get that CST reevaluation cooking as soon as possible if you're having thoughts about discharging the person, by their commitment end date. And that's important because it's super, super important that you and the DFP are on the same page. Certainly, the discharge decisions for committed patients are primarily on the treatment teams. However, the DFPs, we also can weigh in and give you our thoughts as well. And so it's important that we have enough time to sort of get on the same page, get the report written for court, get the potential discharge plans all squared away before that commitment expires, right? So that's just a brief note about that. And I think that is it for our slide portion of the event.
So Ashley, can I just follow up on a couple of things that you mentioned?
Love it, yes.
Yeah, just again, so it's important for the treatment team to stay aware, obviously, of when a patient is doing very well and not sort of wait to the end of the commitment to request a competence update. So again, if you have a patient who, again, because they were psychotic, they weren't able to understand what was going on in court, or they had delusional beliefs that were interfering with their rational understanding of their case, and now 2 months into treatment, they're doing very well, and it doesn't appear that they're experiencing these symptoms anymore, then you want to begin thinking about getting the forensic evaluator back to do an update of the competence to stand trial. You don't want to wait till the end of the commitment. If somebody's doing well, it's not fair to the patient to have to wait. So, and the same holds true when if you're thinking about submitting a 16E for return to the community. You don't want to do that until you've had the forensic evaluator come back and review the competence to stand trial and weighed in on that. So again, you want to make sure you're staying on top of the patient's clinical progress and communicating with your forensic service when either you have questions about the case or when you think it's time for them to come back to do a reassessment.
Well said. High five, low five. Relatedly, and that jogs my brain, another important piece of this is if you're thinking about discharge, if the patient needs an IFRA, it is so crucial that you ask for that IFRA sooner rather than later. Because, what if the IFRA says, no, they're not ready for discharge, but they're approaching their expiration of commitment. And then you've got this battle that has to work its way up the system, and it can be a mess. IFRAs are as an IFRA evaluator, this is also a plea, IFRAs are very comprehensive and time consuming and take effort and time. So the sooner you can initiate that IFRA process so that we're not backing up against the expiration of the commitment, the better for that as well.
This is Imam again. Thank you, Ashley, Paul, and Daniel for this wonderful overview. We have about 35 minutes, and I believe we have questions in the chat room, but I am going to exercise my moderator's privilege, and I'm going to ask 2 questions. One, I am going to direct it to Dr. Olivero. Adeliza, if you could please talk about the 15A screening in the courtroom and what that entails, because a lot of people are curious about it on the inpatient side. And the second one would be to John DiPietro-Antonio, the Deputy General Counsel. If you could kindly talk about 10 and 11 and some of the implications of, voluntary versus involuntary. So Adeliza, you first, and then John.
Thank you, Mom. So the 15A process, as Danielle very well said, can be very complicated. It's most of the time, it's a same day thing. we don't get a heads up or any notifications. The person arrives to the court. Most of the time, they are in lockup. When we do our evaluations, where again, some of the courts, lockup can be a dungeon in the basement with 20 other people hearing the evaluation process. There's no confidential place in most courts to do this type of evaluations. There is no treatment, no medications in lockup. There is a lot of background noise, and it's extremely difficult to conduct an evaluation in that kind of setting. So as court clinicians, we try to get the essential information that's needed to provide the judge with a pertinent recommendation of what we think should happen with this defendant. Most of the time, it's a defense attorney requesting the evaluation, but sometimes the district attorney, based on information in the police reports, or sometimes the district attorney also requests them if the alleged victim is a family member and victim of the alleged crime. They often request this type of evaluations. The judges tend to request the evaluations often if the person is out of control in the courtroom, or if they observe them responding to internal stimuli or acting oddly in the courtroom. We do also do evaluations of people who are not in custody, and those tend to be a little bit more complicated because, again, we need to find a place to interview the person. I would say that average, we spend approximately an hour with the defendant. We review the police reports, the criminal record, and we try to get collaterals, but often it's very difficult to do because of the time constraints. So we focus our interview asking about safety concerns to, again, assess if the person can be evaluated in the future in a hospital or in an outpatient basis. Are there any other specific questions about the 15As?
So Adeliza, that's very helpful. And if any other panelists, they want to add anything about 15A, that would be most welcome. Or if folks have questions. John, if you want to take up 10 and 11, and David or anyone else, Nate, if you want to add to it, or if any other panelists want to chime in, please go ahead.
I do wanted to add that most of the time, the judges do agree with the court clinician, but there are times that they don't. And there are some judges notorious for that. We don't get to choose where the person is going to go, which hospital. The court clinician has to call the area forensic director, and they are the ones that tell us where the client is going to go. There are some judges that are adamant that they want the person to go to a specific hospital. We don't have any control of what the judge is going to write on that order or what they're going to decide, unfortunately. Sometimes there are situations where we recommend to the court that the person needs the strict security of Bridgewater State Hospital. We provide them with information to support that recommendation of why the person should go to Bridgewater, but they don't agree with us. So the person then goes to a DMH hospital, which is, can cause a lot of difficult situations, and we're aware of that. So when we write our reports and when we call the hospital to give oral report, we let the treatment team know so that, again, the staff could be potentially ready and know that what we recommended was not what the judge necessarily ordered.
Thank you, Adeliza. John, if you could, give us a brief overview of 10 and 11 in the next 5 minutes or so. Or anyone else.
John, I think you're muted. Oh, sorry about that. I thought I had clicked it off. Mom, I have one quick clarification. In terms of how it relates on the forensic side of things? Is that what
Right,
you
the
were
key-
thinking?
A difference between a 15 and a 10 and 11, and so. And
Sure.
how- yes.
So a 10 and 11 is essentially the process to allow voluntary admissions to locked psychiatric facilities, and they're also referred to as a CV because it's a conditional voluntary admission. The patient applies or agrees to be admitted voluntarily. There is an assessment that's done that determines whether they're appropriate for admission and if they're competent to consent to an admission. If both of that is in the affirmative, then this quote, as described under the statute, application can be accepted, and the person is on what we call a voluntary status or conditional voluntary status. And that is different than a 15B, which is a court order. Voluntaries are indefinite. There is no end date. The person remains on a voluntary status until they're either discharged or they file and they have a right to file what's called a 3-day notice of intent to leave the facility. And I'm sure most of you know this, the facility then has 3 days to evaluate, assess, and determine whether they want to petition for commitment. If they do, a hearing is held, and if granted, then the person's status changes to most likely a 7 and 8. As it relates to when they first come on a forensic status, and if their competency changes from IST to competency, or if they're determined to be competent, there are times when the patient is sent back to court and they're asked to come back on a pending 7-8 petition or a Section 12. There's also provisions under the statute, both Section 15 and 17, that if a person is in need of continued treatment, and they in the hospital or facility is willing to accept them and continue treatment, then they can come back on what's called either a 15B remand or a 17 remand. And those are what I would describe as essentially forensic voluntary admissions. They only last, however, for as long as the patient wants to remain there voluntarily, or if the facility determines that they no longer need to be admitted. The trick, though, is if either of those events occur, they have to be returned to court. And I'm talking now under the remands, and there may not necessarily be a court date, in which case there would be, and with the assistance of legal, outreach to the court to notify them and have a date scheduled so the individual can return. I will say this, and I can answer any more follow-up questions. I would encourage to consult with legal and talk with legal in these circumstances, because one of the things we want to be wary of is when it's, especially when it's when it is a forensic situation, the DA is involved. They have rights under Chapter 123, and we want to make sure that we're not cutting off their rights or doing something that might be not necessarily contrary, but that may somehow prevent them from exercising certain rights that they have under Chapter 123. So what I would put out there is, don't hesitate to reach out to the legal department and consult with us on the particular situation. Many times it does come down to the very specific facts of that circumstance. I hope that answers everyone's question.
I think so. That's a wonderful overview on 10 and 11 and some of the related conditions, John. Anyone else, any other panelists wants to add on that, on what John said?
Actually, can I jump in on something else? It was just a question John Stout had asked
Go for it.
Bill. I
Please.
was going to type, but it's such a long response. It's just easier to give it verbally. John, the question was criteria for bail amount and if bail can be posted if someone is deemed competent. Can bail only be posted if someone's deemed competent to stand trial? The second question, bail can be posted regardless of the competency status. You can either be
Yeah.
incompetent or competent. It's not a barrier. Now, the factors for bail, and this may have changed a bit from when I was a prosecutor, but if it's not the same, it's pretty close. Is statute indicates numerous factors the court can consider. The purpose of bail is to ensure that the defendant appears at court for the remainder of his court dates. That's the sole purpose of bail. The factors they consider, which go to it, are the seriousness of the offense. Theoretically, the more serious the charges are, the more likely you're getting jail time, which would cause someone to be more likely to not appear to court. The history of their appearance in court before, if they have a history of defaulting on cases, they're more likely for the court's going to impose a bail on the individual. Also factors, and this is most relevant to us, their courts have determined by case law and statute that someone's a greater risk of flight and is a factor in support of imposing a bail on an individual if they have history of drug issues, both drug sales and drug use, and also if they have a history of mental health issues. Factors that go in support of someone not being held on bail are their ties to the community. And those are some of the factors. And also the strength of the case against the person is also a factor for bail. Hopefully that answers the question.
Thank you, David. That's really helpful. Now, unless people have questions, I'm going to start reading the chat room questions and comments. Please raise your hands using the Zoom function if you want to.
Ma'am, if
Go
I
ahead.
may, before you do that, I wanted to briefly talk about the issue of substance use disorders when we're doing 15As, because I think it's
Cool.
important.
Absolutely, go for it.
So as I mentioned, we don't have any type of clinical screenings in the court clinics or in the courts. So rarely we can verify if a person is intoxicated at the time that we are evaluating them, other than if the police writes us in the report or from our clinical observations. So especially people with dual diagnosis, it can be very challenging in the setting of a court clinic to assess if the competence-related issues are related to the underlying mental issue or the acute intoxication. So several different court clinicians and different courts have different ways to assess this. Sometimes some judges allow, if the person is gonna have bail, for the person to be sent overnight or over the weekend, stay in jail, see if they can be detox, return to court, and then the competence can be reassessed. Sometimes judges say if there is a question of a mental illness, then we will just do a 15B and send them to the hospital, regardless if it is at the point in time, if it is related to their mental health or their substance use disorder. I know from experience that sometimes people are sent under a 15B, and it happened to be that they were intoxicated with crystal meth at the time right before coming to court, but they look completely psychotic. It's sometimes again, depending on the collateral information that we are able to get in the very limited time frame that we have, it may be impossible for the court clinic to have that information. And so the person, I understand sometimes it's there for 20 days where they may not necessarily need to, but those are unfortunately becoming more and more frequent because of the, best defendants that are unfortunately under the influence when they come into the court or when they commit the alleged offenses.
Thank you so much, Adelisa. That's really helpful. I want to go back to the chat room questions. In the meantime, please keep the questions coming. This should be interactive. You know, we have people from all the disciplines trying to answer your questions. Number one is, this is for Dr. Renchak from Attorney Moore. The question was, do the DFPs do collateral interviews? Because the slide says yes, and you might have said no. So Danielle, you want to clarify that? You can do collateral interviews.
Yes. So, sorry if I misspoke, but essentially, we can do collateral interviews without releases of information as DFPs. But what we can't do is get medical records. So we could do like interviews where we're not releasing any information, but just gathering it. But that does not allow us to get any medical records for a variety of reasons. So if the patient is not willing to sign a release of information, neither the treatment team or the DFP can get those.
Thank you so much. The second one is from Dr. Arakan at RAP. And this is not essentially within the scope of this training, but if any panelists want to answer, can speakers clarify the special requirements for evaluator to be able to obtain medical records of evaluees in SUD treatment settings, meaning RAP clients 42 CFR Part 2. Anyone wants to take that up?
Aman, I'll jump in on this.
Go for it, John. Yeah, thank you.
I'll be honest with you. I don't have there's several requirements under 42 CFR. I don't have them committed to memory. I will say that an individual needs to specifically authorize release of substance use records. A general HIPAA release would not be sufficient. If it referred to just medical information, it would not be sufficient. It has to specifically authorize or note that it's substance use records. The only other thing I would note there is obviously the individual can authorize it, and if it's if the authorization is specific enough, they can do it. In order to get it through a court order, et cetera, then that's going to be a much different process.
Thank you, John. Anyone else wants to add on that? All right. And John, Dr. Arakan could reach out to you with follow-up questions, if any.
Yes.
Absolutely.
Can I jump in on that, Imam?
Go for it.
Yeah, just actually, John, have you looked at the DMH, this sort of standard release of consent for release of information? We do have a box to check about whether it would include substance use information. Is that good enough for a facility like RAP?
If it comes from the individual, yes.
Okay. Thank you.
Thank you, Paul. The next question is from Dr. Weil, who's a psychiatrist at Tewksbury, and it's a long question. We recently had a court discharge on a patient who, this thing is moving. I'm sorry. Who we were.
I can just state the question. So we
Go for it, Jordan.
was here on I think it was a 15B. Went back to the court. Our intention was to commit him, but the court just discharged him. And I think I might have misunderstood something in one of the slides. Basically, this guy bounced back, and now he's here again. And I want to make sure that really sure this time that he doesn't get discharged by the court. Like, do I have to send him with a Section 12? Like, how do I make sure that the court does not? If the court dismisses the charges, but I think he needs to come back here, how do I make sure he comes back here?
Good question, Jordan. So let's have one of the panelists take that. Anyone?
I do a Section 12.
Yeah, that's what I would
do. Keep in mind, the court doesn't necessarily, they don't have to send them back to you, but they should.
And was this this is a patient who was returning after a 15B?
Yeah, so he was going, I didn't have him the first time, but he was here on a 15B. He got sent back to the court and the court discharged him, even though we thought he needed to be committed. And, now he's back because he got up to doing sort of the same stuff that he was doing before and, didn't get the treatment that he needed. So I want to make sure that, and he's here on a 15B again. I want to make sure that he doesn't end up getting sent back, getting discharged to basically discharged to the street again.
So that's going to happen from time to time in spite of everything we do, unfortunately. But in order to minimize the chance of that happening, again, it would hopefully be spelled out clearly in the report going back to court with the patient that the hospital is looking to get the person back, and ideally a 12E would go with that person in the event that the charges are just dropped. And one of the things that the forensic evaluators can do is speak to the court clinician in the court to give them a heads up, if there's a concern that somebody charges might be dropped and the court, has the potential to just let them go. So, if the court clinicians are given a notice on that too, they can intervene. And I imagine that's come up for you, Adeliza.
It does many times, and we greatly appreciate the heads up. Because unfortunately, as everywhere else, we are in a staffing crisis. So many courts are now without a court clinician. And if you ever are in that situation where you can't reach the court clinician, please feel free to reach out to the forensic area director of the region of the court where the patient is going to go. And they can communicate with whoever is covering that court or try to make the court aware of what the recommendations are going to be.
Thank you, Adeliza.
Yeah,
I want to make sure. Go ahead, John.
Mom, if I could just follow up quickly on that, as Dr. Noroyan and David pointed out, the court is ultimately going to do, whatever they want to do. And I think my advice there is sort of be leery sometimes to, try to anticipate what a court may do in some instances. For instance, a patient may be on bail and there might be assumption, the court's just going to take them back and admit them to a correctional facility. That may not be the case. They may, I can think of a bunch of different scenarios about bail status and why it may change when a client goes back. And there can be a circumstance where bail will be addressed once they return to the courthouse, and the court may decide to release them at that point.
Thank you, John.
Sure.
The next one is Ademola, who's a psychiatric nurse practitioner at Worcester. The question is, who do we follow up with after requesting the competency update? Anyone wants to answer that?
I'm sorry, are you asking in regard to the court, or are you talking in regard to the DFPs for to see who's going to do the competency update?
Ademola, you want to clarify your question?
Yes.
Go for it.
My question is, after the team requests a competency update, how long does that process take before we get an opinion from the evaluator and decision from the court? Can you hear me?
Yeah, I probably should be one of the DFPs should answer that, as they're the ones who would do the 17As.
Ashley, Danielle, you want to take that?
Sure, yeah. So you would request it, I think Cindy Serene gets those. Danielle, correct me if I'm wrong. And then as soon as we get the referral from the team, they assign it to a DFP. And then I believe we have about 30 days to complete it. And so within, a week or two, the DFP will be reaching out to the treatment team saying, hey, I've been assigned this case. And I'm going to be doing this update evaluation and scheduling the interview and talking with you. So I hope that answers your question. It takes about 30 days, I think we have for that.
Thank you.
And if I could just add something to that. So like, for example, Tewksbury or folks that are asking us here at Worcester to do a 17A, I would recommend asking for that like 60 days ahead of time if you can, because we take about 30 days to do that evaluation. And then if we're opining together with you that the person is going to be discharged, we have to give the DA notice of that. And so at Worcester, we usually get them about 60 days before they're due, if their commitment is expiring.
Thank you, Daniel. I am seeing some section 12 related question that Nate in chat room is trying to answer, but would you like to speak a little bit about that, Nate?
Sure, I've been doing the chat stuff because I always freeze periodically when I do these from my office. So pardon me if that happens. But different types of 12s. So the typical 12 is a 12AB. That's the pink paper where the A is the front side and the B is the back side. So only certain people can do a 12A. What is it? A licensed physician, psychologist, licensed independent clinical social worker. If it's an emergency, a police officer can apply for and somebody to be restrained, so to speak. And usually these go to the ER to be held in the ER, and then they get 12B'd at a facility, a locked psychiatric facility. That's what most folks are used to. A 12E, to which some folks have been referring in this presentation, is an application anybody can make. It's supposed to be made in district court, but I think we've done it in Superior Court a couple of times, where it's a form that says 12E, you fill it out, you say why the person needs to be held 3 days involuntarily. And the way this is supposed to work in the community is somebody comes in off the street, takes the form, fills it out, gives it to the clerk, the judge gets it. If the judge is concerned about the person out in the community, they issue what's called a warrant of apprehension. The police will actually pick the person up and bring them into court. Court clinician then is supposed to evaluate them pursuant to commitment criteria and whether they would 12 the person. Then they present it to the judge, and the judge says, okay, I order this person to whatever facility for 3 business days. And then it acts very much like a 12B.
Thank you, Nate. There are 2 questions that I would love if the panelists could respond to. One is about 18A related from Dr. Priyanka at Worcester Recovery Center. And the question is, Dr. Priyanka, do you want me to read the question or you want to ask? If a patient is committed, go ahead.
We can do either. So basically, this patient has been committed on an 18A, will be expiring on in a few months. She's ready to step down, but she'll need a comprehensive plan for discharge given her history and risks. We have contacted the attorney to get her charges worked on, resolved possibly, but he's saying that I don't think the judge is gonna do much about that. She probably needs to do half the sentence before we can even look into this. That would be 18 months of waiting. And because of the legal barrier, community is not really looking into the things that we want them to start exploring, like a GLE, for example. So that's kind of leaves us with limited options. So my question was, the 18A can be renewed, and who renews it, right? And what are our options at this point so that we can help the patient move forward?
Thank you, Dr. Priyanka. Any takers?
Well, I'll jump in here. As far as who can renew it, typically, there are 2 18A commitments. There's what we call the small 8A, which is when individual is at a correctional facility, they're examined, they're determined to be in need of hospital level of care, and then they're admitted, the matter is brought in, before the court, and they're admitted for 30 days, and that would be to a DMH facility. At the end of those 30 days, the facility can then petition for commitment, and that's similar to a 7 and 8 commitment or a 16B commitment. And David, Nate, correct me if I'm wrong, but I think that initial commit it's for 6 months and then 1 year thereafter. But it would be the facility who is filing a petition to keep the patient at that point.
I'm sorry, John, can I add on to that? Just a second
Yes,
part of the
yes,
question? I
please.
think you had asked about, the question was in regard to what you can do for discharge. Just keep in mind, if they're in an 18, that means they're either held on a bail or serving a sentence. So being discharged from the hospital, they're going back to jail, or if it's a situation where they're held on a bail, either criminal case gets disposed of or they post a bail. Otherwise, the discharge is jail. Once they're no longer in custody, meaning either the sentence ends or the bail is paid or posted, or the court decides to reduce the bail to personal, then they're no longer held in the 18. Automatically, it ends. Hopefully that.
So-
Sorry,
This
sorry.
this
I
is a
would just-
case of somebody committed for treatment,
Yes.
correct?
Yes,
Yeah,
for
so
6
it's-
months already. Sorry, I'm interrupting. She's competent to stand trial. We cannot do much about her moving forward because of the legal barriers. I do not know what else we can do, like the 18A can be extended, or we need to file for 7 and 8 while she's on 18A. I don't think that can be done, right?
No,
Wait, I'm sorry, are they on an 18 or are they on a 16 in your example?
18A,
you're on an 18.
Okay, then you'd refile under 18.
who is
Yes.
gonna
You
refile?
do,
The hospital
sorry.
will.
You will. So it's not your, to answer the earlier part of your question, the DFP, once they're committed on the 18A the first time, where the DFP did the 18A evaluation, then it's in your hands as the treating psychiatrist. So any
Yes.
subsequent recommitment is you doing that hearing. And because they're on an 18 and the court's unwilling to, drop their bail status or their sentence, yeah, you can't really do a 7 and 8. You would have to just recommit them on 18 unless you felt they were able to return to the correctional environment.
Yeah, I don't think that should be done for her. So she can't sign in voluntarily. We can't do any other section,
So-
what I'm hearing.
So,
Correct.
So
Yes.
theoretically,
So-
under 18, there can be a 10-11, but the DOC would have to sign on and they'll never sign on. So even though statute permits it, if the DOC is in agreement, it will never happen. You'll have to file another 18.
thank you, David. And we have about
Quick
2
question
minutes.
to that. There's an 18B as well, right? That's a voluntary.
That's what he was just referring to, yes.
Yeah, that is one.
But the
That doesn't
facilities
happen.
don't really use it anymore.
It won't happen. They won't, they will not ever agree to it, and that's their policy. So you'd have to file a new 18 commitment at the expiration.
Yes. So
Thank you.
unless someone has a final comment, I would invite all, everyone to give a round of applause to the esteemed panelists who found the time to do this training. And I am so sorry that we didn't get to all the questions, but feel free to reach out to the panelists or to me or to Julianne Flynn. And Julianne, thank you so much for helping us put this training together for the Office of Inpatient Management. And all the panelists, they're volunteers, so I don't know how you found the time, but you did. And so a level of personal gratitude from me. If someone wants to say, Jonathan, you want to say something? Jonathan Carvalho, Office of Inpatient Management. All right. We're going to stop here. Thank you. Julianne, you have any other housekeeping things you want to say?
The only thing I will just remind folks is if they do want to receive credit for this and to make sure that they do get any emailed correspondence like the presentation, just make sure to email me, because not everyone's name shows up as their actual name as I'm looking at the Zoom logins. Most people I can decipher, but if you did not register, I can't guess, for so many folks. But if you just want to reach out to me, I'll make sure you get the evaluation and any materials.
Well, on that note, thank you so much, Julianne. Thank you so much, all the panelists, and thank you so much for all the participants who joined, taking time out of their clinical day, work day. So thank you so much. We'll do this again in June 2nd, Thursday, same time. Have a
Yes.
good day, everyone.
All right. And
Bye.
thank you.
Thank you.
Bye.
Bye,
Thank
everyone.
you.
Bye.
Bye.
Thank you.